Okay, good afternoon, everyone. Thank you for joining us. I am going to jump right in with an introduction, and then by the time everyone joins, hopefully we're into the substance. We're so grateful to have you joining us today to talk about Title IX. We are going to tell a little bit about the brand new resource that our three organizations recently released titled Protecting Title IX. Today, we're also going to talk about what Title IX is, what you should know about its implementation and enforcement, some of the recent changes, both substantively and with regard to due process, an update regarding the ongoing federal litigation. And we're also going to touch on the election outcome just briefly and end with an opportunity for Q&A. So I'll mention right now, if anyone has questions at any time, please utilize that Q&A function, and we will save some time at the end to address any questions. I have to mention this is not intended to be legal advice. All three of us are attorneys, but really this is to empower you, educate you, especially school board members and district administrators, parents, to discuss Title IX in your local communities and your various networks and make well-informed decisions for your communities. So even though there will be a new administration due to the election results, this is still an important issue, and we'll touch a little bit on why that is as well. And before anyone starts to take notes, you're certainly welcome to do so, but I'll also mention that this is going to be recorded and shared online afterwards as well. So you will be able to see a recording. Now, before I jump into an introduction, I want to introduce our presenters today. My name is Corey Brewer. I serve as Education Counsel at the Wisconsin Institute for Law and Liberty, so I work on both policy and legal issues related to K-12 education. Also with us today is Kim Herman. She's the Executive Director for the Southeastern Legal Foundation. Since 2009, she's been working with SLF, where she's dedicated her legal career to the freedom-based law movement. Kim advances liberty through litigation in federal and state trial and appellate courts on issues ranging from government overreach, free speech, property rights, economic liberty. SLF is representing Moms for Liberty and Young America's Foundation in a lawsuit challenging the Biden Title IX rule. And then our third presenter today is Paul Zimmerman. Paul serves as Senior Counsel, Policy and Regulatory at the Defense of Freedom Institute for Policy Studies, or DFI. He leads DFI's Teacher Union Accountability Project, assists with its federal agency transparency and oversight efforts, and he holds a bachelor's in political science from Duke University and earned his Juris Doctor, his law degree from Georgetown University Law Center. He is a member of the Maryland and District of Columbia bars. Each of our organizations are related. We have more information available online about kind of each of our missions beyond just what the three of us do individually. So I would welcome you to kind of review that as well if you're interested. But like I said, we're thrilled to be able to be a resource to all of you and to share this information today. Now, I think if we're going to talk about Title IX today, we need to start with what is it? And many of you are familiar with this, but I think it's always worth repeating. Title IX is a law passed by Congress. This is where courts start. Title IX of the Education Amendments of 1972. It says, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So this is the federal statute that prohibits discrimination on the basis of sex. And this has not changed. And I'm going to turn then to federal regulations. In this presentation, if we mention the new rule or the new regulations, just know that we're referring to the same thing, the same set of federal regulations. And our resource guide includes a little bit of a deeper dive into what this means, but as an overview today, I think everyone should just know that federal regulations are essentially rules created by an executive branch agency to implement the laws passed by Congress. Title IX is a federal statute that prohibits, as we just said, sex-based discrimination in federally funded education programs. And there are specific exceptions outlined in that law. To establish regulations, agencies such as the United States Department of Education follow a formal rulemaking process. What does this mean? This starts with a proposed rule. It's followed by a public notice and comment period. Just as an example, the Biden-Harris administration's recent Title IX rule received over 240,000 comments. So after reviewing those comments, the agency will then generally finalize the rule, publish it in the Federal Register, and it gets implemented on an effective date. For this particular set of regulations, it was August 1st, 2024. These regulations generally carry the same legal force as congressional laws, provided they do not conflict, and this is important, with the underlying statute or exceed the agency's authority. Courts or Congress can overturn regulations that overstep these boundaries. Regulations also include a preamble, which explains the context of the rule, its background, its justification. The preamble is not legally enforceable in the same way, but it does provide insight into the agency's intent and informs how the rule will be implemented and enforced. So the text that I read previously is related to that law passed by Congress, not the regulations that were just recently changed under the Biden administration. I think it's important to know that that law is not a rule put out by the Education Department or other federal agency. It's not an executive order. It's not guidance. And there is so much to the history of this law. I'm going to give a very brief overview today, just to provide a little bit of additional context. But this was passed in response to the fact that girls and women were being excluded from educational opportunities. There were graduate programs where women were denied access. Girls couldn't access extracurricular activities in the same way, like sports. The list goes on, but the point was that everyone would have equal access in educational opportunities without regard to sex. And at the time it was passed, sex meaning male or female. When it was originally passed, we didn't have the regulations immediately that came with it with regard to the specifics of implementation. Those first came out in 1975. And during these early years, there were also some things related to Congress, making sure that schools and everyone understood that having access to separate facilities, for example, fraternities and sororities, things like that did not constitute illegal discrimination on the basis of sex. And continuing on with this timeline, the Department of Education was created by Congress in 1979. That's why you can see here on the screen, the 1975 reference is to the HEW, but Ed, or the Education Department, was given the power to implement and enforce Title IX at all schools receiving federal financial assistance. So for the first 20 or 25 years, we kind of saw this consistent strengthening of protections for girls and women in education. I'm going to jump all the way forward now to 2020, which I think is really important to our discussion today. There is more about the history available in our comprehensive resource guide if anyone is interested. And all three of our organizations as well would be happy to kind of be a resource if there are questions in that regard. But in 2020, we got from the Trump administration a new rule, the 2020 Title IX rule. This went through notice and comment. It was kind of under Betsy DeVos. The Education Department under Betsy DeVos it formally adopted the objective standard for sexual harassment, which we will get into. It also brought the grievance process back in line with due process and requirements under the Constitution. And Earlier this year now, turning to this most recent set of regulations in April 2024, we got the rules that we're here to talk about today. When President Biden took office, he gave his agencies essentially an assignment through an executive order saying they need to go through various regulations and protect gender identity. The Education Department shortly thereafter issued the notice of proposed rulemaking and did go through that full rulemaking process. It was finalized in April of this year, effective date August 1 of this year, and the rule with the responses and comments all together consisted of about 1,500 pages. So that is what our three organizations did, is go through those, create this summary, so that all of you wouldn't have to go through those 1,500 pages. We certainly don't have time to talk about all of the content and all of the changes, but we want to make a few highlights here. And before I do so, I just want to mention that, as many of you know, there is ongoing federal litigation challenging the Title IX rule. The Title IX changes under the Biden administration cannot be implemented or enforced by the Department of Education in about half the country. Specifically, this new rule is being challenged in at least 8 federal lawsuits, and to date, the challengers are 8-0 against the new rule. There have been 8 federal court opinions enjoining the rule, which means essentially that they are putting it on pause while the rest of the litigation plays out. So if anyone's interested, if your state is included, we have resources available in our guide that gives a little bit more detail about that, the states where the rule is enjoined. I'll also mention that part of that injunction, and this is related to the Moms for Liberty lawsuit, it covers schools attended by the members of Young America's Foundation or Female Athletes United, and the schools attended by the children of members of Moms for Liberty. So if anyone has questions about that, Kim will be a great resource, and she can get you connected with any of those organizations if you're interested. Since that injunction applies and is a little bit broader than just the states that are involved, that means the Education Department can't implement, enact, or enforce any of this new rule in any school where this condition applies in any state. So you don't have to be in one of the states specifically covered by the injunction. So whether or not any particular school is covered by one of these injunctions, these cases are likely to continue to proceed. If it were to reach the United States Supreme Court, it could ultimately resolve this issue nationwide. I'll mention too that the Education Department has already filed motions unsuccessfully within the United States Supreme Court in an effort to limit the scope of some of the injunctions. Now, before getting into the substance, I want to talk a little bit about the Office of Civil Rights and how this law gets implemented. So the Office for Civil Rights, or OCR, is a department within the Department of Education. And anyone can file a complaint within OCR alleging a school district's non-compliance with Title IX. OCR then has 180 days to review and decide whether to investigate. Investigations can last 6 to 12 months or more. As you can see on the bottom of the screen here, we have 6 months to 6 years because some of the attorneys on this call have actually experienced an investigation taking at least 6 years. But OCR can also investigate school district policies for Title IX compliance without a complaint. If violations are found, districts typically work with OCR to resolve issues through policy changes, staff training, or other corrective actions before imposing sanctions, such as with the withholding of federal funds, which is kind of a worst case scenario sanction. OCR generally will give districts the chance to comply first. Additionally, the Department of Justice can enforce Title IX. So before moving on here, I want to mention that there have been a few OCR complaints filed. I want to note that the media often refers to these as federal complaints, which is true, but many individuals, this is very common, assume that this means these are lawsuits. These are not lawsuits. They are not adjudicated in court in the same way that a lawsuit is. They are administrative complaints to the United States Department of Education. How those will be handled and how the rule will be enforced going forward kind of remains to be seen. And just briefly understanding the impact of this rule, assessing risk on both sides, we really wanted to point out that there is risk on both sides. These Title IX regulations, they do have the effect of federal law. Schools face risk on both sides. Complying with the rule could invite lawsuits claiming the department exceeded its authority or that the new rule violates First Amendment free speech rights, while noncompliance risks potential legal action from the other side and possible federal involvement, such as that OCR investigation process that we talked about. In an absolute worst case scenario, the loss of federal funds. But we want to mention that really the intent of this effort, this summary, the guide, the webinar is we want the leaders in our local communities to make well-informed decisions and understand what is in this rule. Understand there's some risk on both sides. Don't feel intimidated or rushed to implement something without fully understanding what is in these policies. And before moving on, here is where I'll talk about what to maybe expect with regard to Donald Trump winning the election. So, you know, we at Will, obviously SLF and DFI are involved in litigation challenging the rule. We believe the rule is flawed. And I do believe the rule will go away, but what that looks like remains to be seen. Whether it's through litigation, whether it's because the new administration rescinds or changes the rule via the rulemaking process or via congressional action. Really, there's a lot that we'll have to wait and see what happens and exactly what it looks like when it happens, how it plays out. We don't have all of those answers. But there seems to be a bit of a misconception out there that this Biden Title IX rule is simply guidance. And I wanted to emphasize that it's more than guidance. It went through the rulemaking process. It cannot be eliminated with the stroke of a pen, just to kind of summarize that. And we'll have to kind of wait and see what that looks like. But based on some of the statements that were made, I would expect the administration to approach these issues from kind of a traditional understanding of what Title IX has meant, with sex meaning male or female. And the last thing that I want to touch on today is another related federal law called FERPA. What happens if Title IX and FERPA are in conflict with each other? How do they work together generally? And we have a lot more about this in our resource guide, so I won't go into too much detail. But generally, if there's a conflict, Title IX will take precedence. As you can see here, FERPA protects the privacy of a student education records. It grants parents a right to access and consent to disclosures. Schools can disclose records without parental consent only in specific legally permitted situations. And our guide includes a little bit of information about what that looks like in the context of Title IX. So I see that a few of you have utilized the Q&A function. Please continue to do so. With that, I will turn it over to Kim Herman.
Thanks, Corey. And one other thing really quickly, just on FERPA and Title IX that I'll add there, is that when we say, that Title IX will take precedence over FERPA, that is in the new rule, right? And so that is one of the many, many changes that we see in the new Title IX rule, Many of you know that the 2024 rule encompasses about 1,500 pages, right? The administration put out the rule and it responded to some of the 240,000 plus comments in those 1,500 pages. We certainly don't have time to cover all of those today, but I want to focus on the three key changes in Title IX that really turn the statute on its head, right? So we have the Department of Education coming in as a federal agency and fundamentally changing Title IX, a law passed by Congress, unilaterally. It is just deciding to do this on its own. So the first major change is the change to the definition of sex. For 52 years, sex in the context of Title IX has meant biological sex, a man or a woman, a boy or a girl. The rule repeatedly refers to, and when I say the rule, these are the rules that existed before the Biden rule. They repeatedly refer and reference both sexes, one sex versus the other sex. Title IX, the statute itself, refers to boys and girls. The concept of gender ideology was not even something that was discussed or even understood back in 1972. So when looking at actual congressional intent, it is very clear that sex meant biological sex. Step into today in 2024. Under the new rule, sex now means gender identity. Importantly, as I've said, and you're going to hear me say it, and Paul say it, and Corey say it time and time again, Title IX never mentions gender identity. Congress has also tried and considered bills and rejected bills that would change the definition of sex in Title IX to mean gender identity. And that's why the Department of Education went ahead and unilaterally did this themselves. So what does gender identity even mean? Well, according to the Department of Education, gender identity means an individual's sense of their gender, which may or may not be different from their sex assigned at birth. It is a completely subjective standard that could change on the day, given the time, whatever that person wants. And notably on that point, a school is prohibited now under the new rule from asking for evidence of somebody's gender identity. So if somebody comes in, a child comes in, a student comes in who is a biological boy and says, I am now a girl, I am suffering from so-called gender dysphoria, the school cannot say, well, okay, let's have a meeting with your parents, let's get the medical records, the diagnosis. They are not allowed to ask for any evidence to that effect. So they have to take the 5-year-old, the 14-year-old, the 23-year-old, talking about college or grad school, at their word. Okay, next slide. The second major change that builds upon that is a change to the scope of sex discrimination. So as Corey walked us through, Title IX prohibits discrimination on the basis of sex. Well, when you change the definition of sex, it expands the scope of Title IX. Now, under the new rule, Title IX prohibits discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, which is just another way of saying abortion, sexual orientation, and gender identity. I want to pause here because something that we've heard and a question that I'll frequently get is, well, who cares if Title IX is expanding the scope, right? It's a civil rights statute. It's here to protect against discrimination. So why does it matter if it's protecting discrimination against all these additional categories? Well, it's actually quite significant because by expanding the scope of Title IX to prohibit discrimination on the basis of something like gender identity, you are actually completely wiping out the books its prohibition on the discrimination based on sex, because you are taking away the privacy rights, you are taking away the protections that Congress afforded to our girls and to our women to ensure them of equal opportunity to educational opportunities. Let me explain how it does that by talking about the standard, which is on the next slide. So what does someone have to establish or show? That's what we mean when we say standard. It's just a fancy legal way of saying, what does somebody have to show to establish a claim for sexual harassment under Title IX? What does somebody have to show to establish a claim for discrimination under Title IX? Well, we have a thing called the Davis standard. The Davis is the name of a Supreme Court case that came down in the 1990s. The Supreme Court said that if somebody is going to establish a claim for sexual harassment, they need to show that there was unwelcome conduct that a reasonable person would determine is so severe, pervasive, and objectively offensive, so really bad, happening a lot, and objectively offensive, that it effectively denies a person equal access to education. So we've got 3 elements there, 3 key elements: severe, pervasive, and objectively offensive. So what would a reasonable person in that situation, would they deem it to be offensive? and it has to deny the person equal access to education. So you're looking at an entire educational experience, the entire educational opportunity here, not just one particular day or one particular incident. The Supreme Court gave us that standard in the 90s, and that's the standard that was followed in our court system. The Department of Education notably declined to ever fully adopt this. It would change the standard with the whim based on the administration. Paul's going to go into this a little bit more in his part of the presentation, but in 2020, under Betsy DeVos, under the 2020 rule, the Department of Education formally adopted the Davis standard. So now somebody who has suffered from sexual harassment and discrimination knows what they have to do to establish a claim, and somebody who is accused of that conduct knows what the elements are and is put on proper notice to defend themselves. So what does the new standard look like? And I know this is a lot of legalese, but I am going to break this down in a very easy, what I think is a very easy to understand example, so that you can see how these standards play out. So under the new standard, a person can establish a claim when they show that there's unwelcome sex-based conduct. I'm going to pause there because we all know that sex here does not mean biological sex, right? Under the new rule, it means sex characteristics, gender identity, sexual orientation, all of those things that we saw on the prior slide. So unwelcome sex, fill in the blank there, based conduct that is subjectively and objectively offensive. So we now have a subjective component to this. It's what a person feels, how that person hearing it or on the receiving side of this, how they feel about it and whether they find this to be offensive or not. It's so severe or pervasive, so the and becomes an or, and it either has to be up to a certain level or it has to be happening a lot and can be just very minimal, and that it limits or denies a person's ability to participate in or benefit from an educational program or activity. So no longer looking at the entire educational experience. Let me give you an example, and this is going to be built upon later when Paul talks about due process. You have a girl, 15 years old. She goes to class. PE she has to dress out for, right? This happens every day. It's happening right now in our high schools across this country, or even middle school. We could talk, my child is 10 years old and in middle school. We could talk about a 10-year-old in middle school. They have to change for PE, goes into the girls' locker room. A biological boy comes into the locker room and says, I'm changing in here today. He's either identifying as a girl that day, maybe he identifies as a girl every day. I really don't know, but that day, all that matters is that he wants to change in that girl's locker room. Your daughter says, please don't change in front of me. I'm uncomfortable undressing in front of you. Can I please have an alternative place to change? Any litany of things, right? The list could go on. Any comment that references his sex characteristics, so the fact that he is biologically a male and has male body parts, or his gender identity, any comments to either of those things, right? He is then subjectively offended. He doesn't like it. He does not now want to dress out for PE. And so he says, if I can't change here, I'm not participating in PE. And he is now deprived the benefit from an educational activity or program, which is the PE class. He now has the ability to file a Title IX complaint against your daughter simply because she did not want to undress in front of a biological male or see a biological male undressed in front of her. You could be talking about kids as young as 4 years old in a bathroom, change locker room to bathroom, right? This should make every single person in America, every single parent out there pause and think about the reality of what this Title IX rule does. It puts our young girls, our women, even our boys and our men, because my son does not want to change in front of a girl in a locker room any more than my daughter wants to change in front of a boy. It puts them at physical danger and it robs them of their privacy and dignity rights. That is a problem. It also robs them of their First Amendment rights. And this is front and center in the lawsuit where we represent Young America's Foundation and Moms for Liberty members. In that case, in issuing the preliminary injunction, the judge explained that in a situation like this, the girl would have no idea if what she would say could rise to the level of disciplinary action. the rule is so vague and so broad that it could be interpreted that anything she says in that situation could mean that she risks a detention, expulsion, suspension, you name it, right? Any number of disciplinary actions. And because it's so vague and overbroad, that it violates the First Amendment. And when asked in open court with situations similar, not identical, but situations similar to that, the Department of Justice attorney could not say whether or not those statements, similar to the example I gave, would be allowed or not allowed. And so not only does this put them at risk of physical danger, it also violates our students and our children's First Amendment rights. Can we go to the next slide, Corey? A little bit more on sex separate facilities, and this is for the school board members out there, okay? Under the Title IX statute, so what was passed by Congress, it protects the rights of girls and boys to have those sex separate spaces. So our living facilities, our fraternities and sororities, there's specific exclusions in the statute. Under the new rule, it requires schools to allow everyone to participate in school-related activities and use whatever facilities based on whatever gender they assert rather than their biological sex. So how does that marry itself with, if we could go to the next slide, what the Department of Education has been saying and has told us, which is that no, we're not taking away sex separate private spaces and facilities. Well, they've created in this new rule what's called a de minimis harm. And this is something that school board members, your county attorneys, your school board attorneys are likely going to bring up. So what is de minimis harm? Well, the rule says that a school cannot carry out different treatment or separation on the basis of sex in a way that would cause more than a de minimis harm. So lots of legalese. So what's a de minimis harm? Well, it goes on to explain that a de minimis harm is anything that would prevent a person from participating in an education program or activity that is consistent with their gender identity. So as we'll see on the next slide, which is, I think it's my final slide, we'll see on this that this is a circular argument, and the courts have done a great job in their opinions of laying out how this is circular. The Department of Education on one hand claims that it won't interfere with the statutory exceptions, but it's also stated that if a school denies that transgender student access to the sex separate facility, that would violate Title IX because it creates more than a de minimis harm. So when you look at that together, the 2024 rule does in effect end sex separate facilities, okay? This is important to note if you're a school board member, because as Corey said, there are different things that you're going to have to weigh. If schools are following the 2024 rule, if they're not under the injunction and the Department of Education is forcing them to adopt this, then by implementing it and getting rid of those sex separate facilities, you are arguably going to be in a position where you would be possibly violating your students' First Amendment rights because they can no longer speak up for their safety and their privacy and their belief in biological sex, and the fact that boys are boys and girls are girls, okay? If you don't, then you could be potentially subject to one of these OCR complaints that Corey mentioned that are being filed against some of the schools that are not adopting the 2024 rule because they are not allowing boys to go into girls' spaces and girls to go into boys' spaces. So I sympathize with school board members because it puts you in a very difficult position. I'll end by saying my hope and our hope in litigating the lawsuit is that we can reach a final conclusion in our lawsuits where the courts definitively say that this 2024 rule is unconstitutional. So in other words, what they've said in the preliminary injunction orders, again, as Corey mentioned, we're 8-0 throughout the country across all of the lawsuits. What those courts have said is that this is unconstitutional. It violates the First Amendment. Some of them have said the Department of Education does not have the authority to change the key definitions of Title IX because that lives only with Congress because it's such a major question and a major part of this law. There's due process concerns. There's many other claims that have been brought in those lawsuits. But to get a final ruling where the courts say, yes, this is unconstitutional, and they vacate the rule, the Department of Education, no doubt, will go back through a rulemaking process. We also could see Congress come in and definitively change the definition of sex. And I don't mean change, I mean actually change it from what the 2024 rule says. But they could go in and say, what we meant in 1972 was biological sex. We mean the same thing as 2024. Sex is now defined as that, and we are done. End of discussion. Okay. So those are just a couple of things that could happen. With that, I want to pass it to Paul so he can talk about due process, which is something that you really will deal with a lot as school board members.
Thank you so much, Kim. And those were great presentations. And I just want to say at the outset that DFI is really proud to work with these two incredible organizations to present this resource. And also to have worked with the states of Louisiana, Mississippi, Montana, and Idaho to secure the first in the nation preliminary injunction blocking the enforcement of the Title IX 2024 rule in those states. So as Kim said, I would like to use my portion of the presentation briefly to touch on the topic of the negative impacts of the 2024 rule on due process in educational programs and activities. Just to do some table setting on that issue. Since 1975, the Title IX regulations have required school districts to maintain grievance procedures that provide for the prompt and equitable resolution of complaints of sex discrimination from students and employees in education programs and activities. Those complaints of sex discrimination are different from what Corey was talking about that are filed with the Department of Education's OCR, which is really a request for OCR to investigate a school district for failing to comply with Title IX. These complaints that I'm going to be talking about are at the local level. They're filed with a Title IX coordinator for the school district, which every school district across the country is required to have under the regulations. And such complaints require the school district to investigate and, if appropriate, address allegations of sex discrimination, which includes sexual harassment and assault. Corey, if you could change the slide, please. So in 2020, the Department of Education amended its Title IX regulations. We've already heard some of that, but I just want to touch on two very important aspects of those regulations. The first important aspect of the regulations that is relevant here is that the Department of Education, for the first time as a regulatory matter, required schools to address sexual harassment, including sexual assault, in their education programs and activities. Secondly, the department recognized that schools, especially in higher education, but also in the K through 12 context, were not living up to the constitutional guarantee of due process that is required before you deprive employees of their public jobs and students of their interests in receiving a public education. And so the department established a baseline for the due process rights schools must grant to their students and employees in Title IX grievance procedures before imposing discipline, which can include such drastic measures as expelling students and terminating employees for sexual harassment in their education programs and activities. Next slide, please. In 2024, a mere 4 years later, the department rolled back many of those Title IX regulations, eliminating some of the due process safeguards that were instituted by the 2020 rule, and in essence, prioritize the ability of each school to kind of pursue its own vision of what due process is required in Title IX grievance procedures. And just importantly, that the 2024 rule applies to all types of sex discrimination, not just sexual harassment as the 2020 rule did. And it expands the school's responsibility to respond to allegations of sex discrimination to any conduct that may reasonably constitute sex discrimination. So not just actual discrimination and harassment, but anything that resembles those things. Also, as we could talk about in the Q&A potentially, it drastically expands the requirement that schools respond to off-campus speech and conduct. Next slide. So Kim brought up an example in PE class. I'm going to work off of that example and modify it slightly to apply to a female athlete in high school who wants to use a locker room. And I think this example is going to lead us into a hypothetical Title IX grievance procedure for the purpose of showing how the Title IX regulations work in concert to impose the ideological dogma of the Department of Education on K-12 schools. First, by redefining sex to include gender identity. Second, by redefining sexual harassment, as Kim discussed very, very helpfully, to include constitutionally protected speech. Third, by drastically increasing the obligation of school districts to respond to speech and conduct. And lastly, by drastically reducing the due process rights of students and employees in K-12 schools. So under the 2024 rule, as Kim mentioned, a school is required to allow a biological male who identifies as a girl to use the girls' locker room. A female athlete, in response to that, complains repeatedly and in the presence of the boy and a school employee who in my example is a track coach, that she has to share the locker room with a biological male. Next slide. So under the 2020 rule, as Kim discussed, there will be no obligation of the coach to report the speech. The school district wouldn't be required to discipline the student or investigate the student for her constitutional exercise of free speech. Under the 2024 rule, the coach would be obligated to report the speech to the school district's Title IX coordinator as behavior that reasonably may constitute discrimination, in this case, harassment, on the basis of gender identity. Next slide, please. The Title IX coordinator, in response to the report, would be required to consider whether to launch the Title IX coordinator's own complaint investigating the female athlete for the speech. The biological male who identifies as female, who wants to use the locker room, and we'll call that person the complainant for the rest of this discussion. The complainant can force the school to investigate by complaining orally or in writing. And the complainant can require the school to launch its grievance procedures, even if he's no longer enrolled at the school. There's no time limit on the requirement of filing a complaint. Next slide, please. So unlike the 2020 rule, the female athlete no longer has a right under the 2024 rule to receive written notice of the allegations. That notice can be given orally. The female athlete is no longer entitled to an advisor of her choice to accompany her to meetings during the investigation. That female athlete also, importantly, no longer has the right to speak publicly about the allegations or the investigation because the school district is under the obligation under the 2024 rule to take reasonable steps to ensure the privacy of the parties is protected, and the investigation can remain secretive under that rule. Next slide, please. Unlike the 2020 rule, the 2024 rule requires schools only to offer an oral description of a subset of the evidence uncovered in the investigation. Now, if one party responds to that oral description by requesting the evidence, requesting actual access to the evidence, then the school has to give both parties access to the evidence. But the fact that it's an oral description of a subset of the evidence in the first place raises very valid concerns that they will not know what kind of evidence to ask for. We're talking about either party here. Let's go on to the next slide, please. In 2020, the Department of Education recognized that some schools were operating under the single investigator model. And in this case, that means that the female athlete would be subjected to a decision by a decision maker in her Title IX grievance procedures And that decision maker could be the same person who is the Title IX coordinator or the person who investigated the complaint. Under the 2020 rule, that single investigator model is abolished, recognizing the extreme danger for bias and that evidence can infect the decision of the decision maker when the decision maker really shouldn't be considering that evidence in the Title IX proceedings. The 2024 rule returns the opportunity to implement the single investigator model for schools. And it returns the danger that people will be subjected to discipline on the basis of the judge, jury, prosecutor, police officer, executioner being the exact same person. Next slide. Maybe advance it one more. Evaluating the allegations. The 2020 rule requires the schools to allow parties to submit questions to ask each other in K through 12 as a baseline. The 2024 rule doesn't require any particular process for evaluating the allegations at the end of the process. The schools get to ask whatever questions they feel are necessary, and they may ask no questions if they don't feel that credibility is in question. Next slide, please. The standard of proof under the 2020 rule, the department recognized that the text of Title IX doesn't set out any particular standard of proof. By contrast, the 2024 rule requires schools to use for sexual harassment and other sex discrimination proceedings the lower, more likely than not, preponderance of the evidence standard for this female athlete's case, unless they use a higher standard in all other comparable proceedings, which includes any kind of discrimination proceeding. Next slide, please. And finally, at the end of the process, the 2020 rule requires schools to provide an opportunity to appeal to either party on the basis of things like bias and on the basis of new evidence. The 2024 rule generally takes that right away from the parties unless the school offers the right to appeal in all other comparable proceedings. However, the school must allow the complainant to be able to appeal a dismissal at any point in the process, a dismissal of that complainant's complaint on the basis that they're not actually stating a case of sexual harassment. So it results in an asymmetry where the complainant can appeal a dismissal at any time. The respondent, who is the female athlete in this case, has necessarily doesn't have any right to appeal at the end of the grievance procedures. And final slide. So I just want to say at the end here that schools under one of the injunctions blocking enforcement of the 2024 rule are required as of this time to abide by the 2020 rule's due process requirements. Even if a school isn't under an injunction, the 2024 rule allows schools to offer, in most cases, baseline due process protections to students and employees accused of sex discrimination and harassment that do align with the 2020 rule. And in making that decision, schools need to consider litigation risks, people challenging those procedures in court, as well as just principles of fundamental fairness and equitability before abandoning the stricter standards of the 2020 rule. Thank you.
I think we're going to answer some of the Q&A now. So Corey, I didn't know if you wanted to lead it or if you want me to just go ahead and jump right into one of the questions that we see a lot of that relates to some of the litigation.
That sounds good.
Okay. So this doesn't relate directly to the resource or to the scope of Title IX and the changes in it, but this is a question that we've got a lot in the Q&A, so I want to address it. A question as to the scope of the injunction and specifically some of the lists that have been filed of schools. So if you look across the board in the various cases, and I can speak to ours specifically, Paul may have something to add with DFI's lawsuit, but the courts have enjoined the Department of Education from implementing and enforcing these new changes at the schools that are covered by the injunction. So in the 26 states, at all schools with a member of Young America's Foundation, Females United, stumble over that one, and at schools where there's children of Moms for Liberty members. The injunction is on the Department of Education, okay? The injunction does not necessarily stop schools who want to change their policies from changing their policies. They are not parties to the lawsuit. That does not mean that you have to necessarily change your policy. That's something that you need to talk to your legal counsel about, because as we mentioned, changing the policy could open you up to litigation. Not changing your policy could open you up to litigation. Unfortunately, we don't have that silver bullet answer for you. That's something that you have to talk to your attorneys about if you're a school board member. As Paul mentioned, with respect to the due process requirements, you do not necessarily have to adopt the new 2024 changes. You have a lot of leeway with respect to that. And he may want to add on to that in just a minute. I want to address the list since I'm talking here. In our lawsuit, the judge instructed Moms for Liberty and Young America's Foundation to provide it with a list of schools that would be covered by the injunction. That doesn't mean that the scope of the injunction is limited to those schools, but the court has to have some way of enforcing the injunction. So we have periodically been filing notices with the court. The last one we filed was just about a week ago. A question that I see about 10 times on the Q&A is, when are you filing the next list? I don't know exactly when we're filing the next list. We are fully briefed in that case, and we hope that the judge will vacate the rule so that this is no longer a problem and we don't have to continue filing lists. So with that, Paul, I'll kick it to you if you have anything to add about the scope of the injunction.
I think you covered it well.
Yes, and I see several of the questions here are related to that. So hopefully we touched on several of those questions. One thing that I see here is related to gender transition, gender support plans for students, and specifically such plans that do not require parental notice or consent. We go into this in more detail in the guide, which Eric Searing from Will here has posted in the chat for ease of reference. But I want to mention that the department has said that nothing in this new Title IX rule, the Biden 2024 rule, should be interpreted to infringe on parental rights. So as far as we know, they're not interpreting this new rule to require parental secrecy. I mean, we know those policies are out there. Our legal team at Will and several others across the country are litigating these issues as an alleged violation of parents' constitutional rights. However, when it comes to Title IX, as far as we know, the department has at least taken the position that it shouldn't be interpreted to require that parental secrecy.
Another question I see on here, and this is a question that we get a lot, is can we expect an executive order on day one of President Trump's next term with respect to Title IX? It's hard to say, right? He's come out and he's been very vocal about this issue. Many commentators out there have said that the issue of gender ideology in our schools was a sleeper issue in this election, or it was a silent issue that people went to the polls and really made a statement about. And so I wouldn't be surprised if we see an executive order. But as we've also talked about here, this is a rule that has been issued and formalized by the Department of Education. So it cannot be dismissed by an executive order, right? President Trump can tell the Department of Education, I want you to go get to work to make changes here, and to other agencies that are doing similar things like the Department of Education, right? This issue is not necessarily isolated to one federal department. But that's all the more reason why we need to be successful in these court cases. We have 3 branches of government. Our courts are just as important as our other 2 branches of government. And so we need to continue to see the litigation through. I think I can speak on behalf of our clients that they have every intention of doing that so that we get this rule vacated because of its unconstitutionality and the other statutory issues with it. I also expect to see Congress, as I mentioned, propose some bills and some laws that will change again, change from the 2024 rule, but solidify the original congressional intent, which was that sex means male or female biological sex.
We still have about five minutes here, so we're going to continue to try to hit on as many of these as we can. One question I see that came up is related to athletics, so I will touch on that, and I think probably Kim and or Paul will have things to expand upon. But one of the questions that we've gotten a lot is, does this rule apply to athletics specifically? And here's another topic area where the department has said it does not. And it actually started the rulemaking process for a Title IX rule specific to athletics. And that proposed rule has kind of been put on the shelf indefinitely. It was never finalized. And so as far as the department has said, this rule doesn't apply to athletics. Now, that's hard if you're a school district administrator, a school board, because as we've been talking about throughout this hour, Title IX applies to educational programs or activities. How do you apply that? You kind of have the burden of figuring that out. And then you also have your state interscholastic athletic associations that might have different rules. You might have state laws that are different. So there's a lot of moving pieces here as well. But Kim or Paul, anything you would add to the athletics piece?
Yeah, I would just echo what Corey said. I think the rule puts school district officials in a tough spot because it bans gender identity discrimination. So what does that mean for sports programs? I think what it means for this administration, the outgoing administration, is that you can't have, they interpret it as saying that you can't have blanket policies preventing people from participating in sports on the basis of gender identity. That's based on court filings that they've made before. But it does put administrators in a tough spot, and I would not say that the rule does not apply categorically to athletics. I would say that it's a much more nuanced situation.
And I'll just add briefly too on the topic of athletics, there are a few cases up at the United States Supreme Court right now where there are parties asking the court to hear these cases to provide some clarity on the topic of athletics. So we might have that soon, but we'll have to wait and see.
And one thing, I just saw a good question in the chat about Chevron deference and Loper Bright and their impacts on this case. I think I'd say two things. One thing is that the department hasn't been relying on Chevron in its cases for its interpretation. It's also lost all of these cases and is subject to these preliminary injunctions. I think rescinding the rule doesn't really implicate the kind of new regime, at least in my opinion. You guys can let me know if you differ. But I think the second point is that it just raises the importance of what Kim's talking about in terms of there being three branches, and there's a Congress that that can act on these things and implement changes that actually comply with the law. And so, if you want to go to that branch and talk and pursue a legal avenue, Congress would be the branch to talk to, not the executive branch inventing a new definition of sex to include gender identity.
Yeah, because when and if we see a new rule out of the Department of Education, there's undoubtedly, it will get tied up with in litigation, right? To the same effect, with similar arguments, just coming from a different perspective. And so that is kind of one of the flaws, many flaws of our administrative state, but that you can end up going back and forth on these issues and never having any real resolution, which leaves parents across the country on this specific issue kind of sitting there and saying, well, what in the world am I supposed to do? How do I protect my child? And it leaves school board members saying, how am I supposed to do my job? What is my fiduciary duty? What obligations do I have? Because I don't want to put us in a situation where we're going to get sued, but we're going to get sued either way. And so, you know, how do we kind of win here? And I would offer that we win by the government following the Constitution and sticking to, you know, the authority that each branch is given in our Constitution, and that's a win for all Americans. So, Corey, if we have time for one, I know we're right up at 2 o'clock, but there's a question that I saw quite a lot, which is what do we do if our state has a law that is similar to these changes? Future lawsuits are going to have to be brought, right? So as we also talk about that, we talk about litigation. If a state has an unconstitutional law that violates First Amendment rights of students or violates any litany of the other claims that are in all of the cases, it is going to mean that parents, or if they want to stop that and change that, they may need to step up and sue. I charge all the parents to think about that. It's important that we get U.S. Supreme Court precedent. And I say that because I'm coming to you as an advocate, not just an educator at this point, since I am litigating one of the lawsuits, that we win the case and set precedent that could then be carried down to challenge other similarly unconstitutional policies. So that's my last thought on that.
Well, thank you so much, everyone, for tuning in. I will mention that our 3 various organizations are glad to be a resource to you all. So please do feel free to reach out. I know we weren't able to get to everything today. I'll also mention that if you signed up for this webinar, not only will a recording be posted on YouTube, but we'll send you a link to the same list of folks that registered. So that should make it easy to access if there's anything you want to go back to or anyone you want to share this with. But with that, thank you for tuning in, and we hope to, like I said, educate, empower, help you make informed decisions in your communities and in your networks. So have a great rest of the day, everyone.